Good evening, everyone. My name is David Stacy and I will be your anchor. Today we have a very fascinating story in the Supreme Court as a recent verdict from the combined case Riley v. California, a case regarding privacy of smartphones and if they are safe against unwarranted searches. With more information, we cut to Wyatt. Wyatt, can you tell us a little bit more about the case?
Thank you, David. David Leon Riley belonged to the Lincoln Park gang of San Diego, California. On August 2nd, 2009, he and other gang members opened fire on a rival gang member driving past them. Weeks later, on August 22nd, the police pulled Riley over for driving a car with an expired license. The police impounded Riley's vehicle and did a routine search. Upon inspection, the police found 2 guns that could be linked to the shooting from August 2nd. The police then arrested Riley for possession of the firearms and seized his phone. They began to search through his photos without a warrant to find evidence that he was connected to the Lincoln Park gang. Riley was convicted of 15 years in prison. In a related case, Remo Worry was arrested after police observed him participate in an apparent drug sale. At the police station, the officers seized a cell phone and noticed that the phone was receiving multiple calls from a source identified as My House on the screen. The officers opened the phone, accessed its call log, and traced the number associated with the My House label to what they suspected was Worry's apartment. They secured a search warrant and found drugs, a firearm, ammunition, and cash in the ensuing search. Worry was then charged with drug and firearm offenses and sentenced to 262 months in prison.
Riveting. Now we'll be moving on to our good friend and law specialist, Katie, who will be telling us more about the Fourth Amendment and the court's decision on this case. Katie?
Thanks, David. Both cases that fall under Riley v. California fall under the rule of the Fourth Amendment. The Fourth Amendment provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath and affirmation, and particularly describing the place to be searched and the persons and things to be seized. In other words, no person shall be searched or have items belongings taken from them without probable cause or warrant from a judge. The ultimate goal of this amendment is to protect the people's right to privacy and their freedom from intrusive actions by the government. To claim a violation of the Fourth Amendment, the government would have to have searched an entity without obtaining a warrant or showing probable cause. When dealing with Riley v. California, we have 2 separate instances of unreasonable searches. In Riley v. California, the court claims that the seizure of the phone was warranted based on the ammunition in the back of the car when Riley was pulled over. The search of the phone led to Riley being convicted of shooting a rival gang member. Similarly, in Petitioner v. Bremer Worry was arrested for distributing crack cocaine. The police seized his phone after it was ringing while he was being detained. Even though the phone was ringing, it shouldn't have prompted investigators to search the phone. They still needed a warrant in order to search the phone's contents. This search led to the conviction of intent to distribute on Worry's behalf. Both courts originally denied Worry's and Riley's motion to dismiss the evidence that was illegally obtained. But once they appealed to the Supreme Court ruled that both phone searches were illegal. In Riley v. California, the concurring opinion of the judges was that the warrantless search of both phones is not an acceptable practice, since it did not put the police officers in harm in any way. There is no dissenting opinions since the court ruled unanimously. To make this decision, the court relied on California's Supreme Court decision in People v. Diaz in 2011, which held that the Fourth Amendment permits a warrantless search of cell phone data if it is directly related to the arrestee's arrest. In both cases, the cell phone was not associated with what the arrestee was being arrested for, thus the search of the cell phone was illegal.
Fascinating stuff. It's very clear that this case is very nuanced. And to discuss that nuance further, we have my 2 co-anchors here who will be discussing the dissenting and concurring opinions of the case. Starting off with our first question up for debate. If a police officer suspects you of doing something illegal, do you think that police officer should have the power to search your phone for evidence?
In my opinion, I think if you have nothing to hide, then there should be no reason why you shouldn't allow police enforcement to search your phone.
I definitely see your view, Jake. However, given this day and age, phones contain so much personal information with photos, search history, and conversation history. Personally, if someone looked through my phone, they would be able to tell a lot about me, who my family was, who my friends were, all the places I've gone to lately, where I work, and all sorts of information.
Yes, your phone does have a lot of personal information, but the police aren't criminals that are out for this info. You should be able to trust the police with this information and know they won't leak this info to anyone else. Also, the police aren't looking to find personal information about you. They're only looking for evidence for illegal activity.
I understand your point that if I have nothing to hide, then I should have no problem handing my phone over to authorities. However, I just would not feel comfortable handing my phone over to anyone.
Interesting points. Moving on to our second question. If the government suspects you of being a terrorist, and they need that information quickly in order to figure out a solution, do you think the government should contact your internet provider and allow them to search your search results and your contact information?
No, I don't think so. I think that the government should have to go through the proper due process to obtain any information that is not readily accessible to the public. If there's strong evidence of behavior consistent with terrorists, then the court should have no problem giving the authorities the proper warrant.
Warrants take time to obtain. The government should be able to search wherever possible to find evidence against a potential terrorist, especially in a state of emergency where people are at risk. I think the government should be able to do everything they can to possibly find the evidence to put away terrorists so that nobody else gets hurt.
Moving on to our last question of the night. Is there any other elements that you think that we should have protection against besides our house, our cars, and our phones?
I believe that my health records and my location data are very private and sensitive information. I would personally just feel very unsafe if the government constantly had access to all this personal information about me.
I think anything that you rightfully own should have protection against the government. However, if you're suspected of being a criminal or even a terrorist, then some of those rights should be revoked. The government should be able to then search for incriminating evidence against you, especially if people are at risk.
Interesting. You both have very valid points, but now we're going to cut back to Katie to discuss a little bit about the aftermath of this case and what does it mean for people like us.
In both cases, under Riley v. California and Petitioner versus Worry, we can see the overall legal and societal impact of the case. Moving forward, the court system will use a new interpretation of mobile device and cell phone. During both cases, the Supreme Court based its rulings on their interpretation of cell phone of today, or 2014, which is similar to a mini computer that contains tremendous amount of information that the search of a cell phone is about the same or even worse than the search of someone's home, which we know requires a warrant. Moving forward, courts will have to evaluate the changes in technology, whether that be smartwatches or smart glasses like Google Glasses, and much more. The court may have to change their interpretations of different technology as time progresses. When viewing the societal impact, we can see the reviews of this case were ultimately positive. People enjoyed seeing the pro-privacy stance of the courts when taking a viewing at the case. People also enjoyed seeing the changes in older search warrant rules to meet with the current time period.
Well, I'm glad to know the government can't get access to my information without a valid warrant. Thank you everyone for joining us, and I hope you have a fantastic evening. This is David Stacy signing off.